Good afternoon. My name is Bill Franz. I'm the General Counsel of the Texas Higher Education Coordinating Board, and I'm here today to briefly talk with you concerning FERPA, which only deserves brief treatment, of course. Just kidding. And the student complaint procedure, which our board members adopted about a week or so ago, and which will actually become effective in about another week, and I'll highlight that primarily. In terms of FERPA, what I'd like to do is, as I said, briefly go over what it is and point out to you that there's a number of recent amendments to the FERPA regulations that you should pay attention to. And I've loaded up a number of slides in your packets for those of you who have downloaded them so that you can take them with you, refer to them at your convenience, use them, and hopefully get some utilization out of those. But real briefly, what FERPA is it's a federal law that's been around now since the mid-70s, and it affords first parents of school children to have a right of access to their children's education records, the right to seek to have those records amended, the right to consent, if they choose to disclosure of those records and to whom, and finally the right to file a complaint with the United States Department of Education under certain circumstances. Secondarily, once a student turns 18, or once a student matriculates in whatever form or fashion to a post-secondary institution, that student assumes the rights that the parent had for all those prior years, and they involve the exact same rights. So the general basic tenets of FERPA have not changed, but the Family Policy Compliance Office, which you'll notice has been very active over the last 2 years in promulgating new regulations, leading the Department of Education in promulgating new regulations pertaining to FERPA that I mentioned at the top. And they have a number of slides from various webinars that the FPCO has hosted over the last year or so that can be insightful and give you much greater depth than we're about to go into today. There is a slide of those recent amendments, and what they have done is really liberalized FERPA to the degree that a lot of us have been asking it to do, it being the FPCO, over the last half a dozen years or so that we can have greater flexibility in sharing data so that we are in a better position to evaluate programs that we fund, that you may fund, that you may have instructors participating in. Everyone wants to know what the outcomes are, and for many states, they've been stymied up until now. Texas has been fortunate, and we've had certain creative methods in order to avoid the more draconian aspects of FERPA. We've set up education research centers, the ERCs, back about a half a dozen years ago, and we've been able to set up pathway projects, all with the FPCO's oversight and approval. The next batch of slides simply gives you some additional background on FERPA. Talks about annual notification requirements. Those are the requirements that compel any institution of higher ed to notify a student of his or her rights. And the primary purpose for going into FERPA today was to highlight the recent amendments that really have broadened liberalized FERPA and its application. So please feel free to review these at your leisure. There's additional guidance documents and FERPA regulations on the FPCO website I've referenced already in the event you would want to consult them for additional information. What I'd like to now go into is the student complaint procedure. And as I said, this is hot off the press, so to speak. The agency has been working with multiple institutions of higher education around the state of Texas for a number of months to fine-tune what we ultimately brought forward as a student complaint process and took to the board about a week or so ago. The background on this student complaint process, it's not as though we were looking for additional work. Rather, the United States Department of Education published and adopted what it termed program integrity regulations that require each and every state to have a process to review and act on complaints, student complaints, pertaining to higher education institutions, including enforcing applicable state laws. Now that, generally speaking, means consumer protection laws, education code laws, etc. Any Americans with Disabilities Act provisions that a state has adopted, any Title VII type provisions that a state has adopted, etc. It runs the gamut. And the states have to have this complaint process in place by next year in order for its institutions to be legally authorized by the state and thus eligible under Title IV for federal funding. The pertinent Texas Education Code section is section 61.031. It sets out what the coordinating board's responsibilities are in handling complaints. And then, of course, we've developed additional clarification through our recent rulemaking. We proposed that rulemaking, I guess it was in late August, and as I mentioned, it was just adopted about a week ago. And what it allows now is for a student complaint to be filed officially with the coordinating board. And what we will do with it, it would be filed with my office, the Office of General Counsel. And what we would do with it is review it, make a determination whether or not we or any other entity would have jurisdiction of such a complaint. And if it's another entity that would more than likely be the agency with jurisdiction, what we would do is refer it to the other entity. For example, if it involves consumer protection, fraud, alleged fraud, that type of behavior by a particular institution of higher education, we will refer that complaint to the Office of Attorney General. And the Office of Attorney General would undertake to determine whether or not it was a complaint that had merit, et cetera, and proceed to, if it had merit, arguably bring suit. It's all up to the Attorney General, of course, and we can't compel that office to do something it's choosing not to, but it would certainly be, in the first instance, the office that's going to take a look at it, investigate it, and make the appropriate determinations. The federal regulation allows, and the feds issued a great bit of guidance. The regulations, the program integrity regulations, are about this long. However, what the feds have done is issued a number of sets of guidance, and it's within those sets of guidance that our rules drew their essence. And they allow, the federal regulations allow for us to refer complaints to university systems for a particular system to handle if the complaint pertains to an institution in the system. For example, if a student complaint comes in complaining about behavior at UT Permian Basin, we would refer that complaint to the University of Texas system for it to handle. And it could handle that complaint from start to finish. It does not need to come back to the coordinating board. Same as with the Attorney General. If a complaint involves the standards of an accrediting agency, such as SACS, for example, we could refer the complaint to the accrediting agency and allow it to handle the complaint. If it's a private institution of higher education that happens to be a member of ICUT, we can refer the complaint per the federal guidance to ICUT for handling. I don't think that will pertain to anybody in the room, but you should be aware that that is another source to which we can forward complaints. Presuming we do not forward a complaint because we think we have jurisdiction, or presuming that that the agency to which we forward it asks that we, for whatever reason, go forward and investigate and handle the complaint ourselves, we will do so. The first thing we're going to do is look for the student complaint form that'll be available on our website. Make sure it's filled out. We're going to talk to the student making the complaint. The first thing we're going to say is, have you filled out the student complaint form? If the answer is yes, the next thing we're going to ask is, have you tried to exhaust or exhausted every grievance or appeal procedure available to you at the institution of higher ed that you're talking about complaining about? And if the answer to that is yes, we'll go ahead and undertake the complaint. And of course, we'll send a copy of it pronto to the institution of higher ed and ask it for its response to the complaint. If the student says, no, I haven't exhausted the appeal procedures, I don't think it'd be fruitful for me to do so, we'd say, we'll try anyway, and then come back to us if it's not fruitful. Hopefully it will be fruitful. Hopefully it'll get resolved at the local level and we don't do anything else with it. That's our hope, and based on minimal experience over the last few years, maybe a decade, that's pretty much been the experience. Because we've done this, as many of you know, informally for years. Now it's a formal process. But presuming we undertake it, as I said, we'd send it to your institution asking for an official response, give you sufficient time. Initially, it's 30 days. If you need more time, all you got to do is write to us or call us or ask us. We'll give you more time if you need it. Once we get your official response, which could involve statements, it could involve documentary evidence, it could involve a combination of both. Once you've responded, staff will put together a recommendation, and if the recommendation is maybe we can resolve it by talking to your institution a little bit more, that's what we're going to try to do. If that won't work, either because you don't want to resolve it or the student doesn't want to resolve it that way, we'll make a recommendation to the commissioner. The commissioner will do one of three things. He will dismiss the complaint if it doesn't have merit. He'll accept the complaint if he believes it has merit and ask the institution, direct the institution to take certain actions to rectify the student's complaint and remedy it. And finally, if it involves an issue of institutional integrity, which we expect to be very rare, examples we've talked about both in-house and at the board meeting are the University of Virginia, Penn State University. Hopefully nothing ever gets that bad. But on matters of institutional integrity, within the sole discretion of the commissioner, he can forward it to the board for resolution, and then it's up to the board what it chooses to do with the complaint. And it would ultimately make a decision, either dismissing the complaint, finding merit with the complaint and directing the institution to do some action to remedy the complaint, and upon the board's decision, the matter is final.